We're going to read this for everybody. All right, shalom everyone. We are here to talk about billing error laws. This is a part of a larger document. As you can see, this is an exhibit in a larger document. This is about 8 pages. We're going to talk about this in relation to challenging debts that are on your credit report, and also debts that you are currently paying, for reasons that you may know or you may not know, but we're not going to get into the reasons. We're just going to read these billing error laws. There are people who are looking for this information. They can never find it. And so we are going to make this a free product that we put out there so people can go read the laws, see how they're being messed up, taken advantage of. So hopefully that they'll do something about it. All right. So first of all, we have 28 U.S. Code 3002. United States means a federal corporation. 15 U.S. Code 1601. The term credit card means any card, plate, coupon book, or other credit device existing for the purpose of obtaining money, property, labor, or services on credit. 12 CFR 1026.13. Billing error resolution. This is Regulation Z. Number 1. Consumer's right to withhold disputed amount. Collection action prohibited. The consumer need not pay, and the creditor may not try to collect any portion of the required payment that the consumer believes is related to the disputed amount, including related finance or other charges. 1. Correct the billing error and credit the consumer's account with any disputed amount and related finance or other charges as applicable. And 2, mail or deliver a correction notice to the consumer. D. Rules pending resolution. Until a billing error is resolved under paragraph E or F of this section, the following rules apply. Number 1. Consumer's right to withhold disputed amount. Collection action prohibited. The consumer need not pay, and the creditor may not try to collect any portion of the required payment that the consumer believes is related to the disputed amount, including related finance or other charges. If the cardholder has enrolled in automatic payment plan offered by the card issue and has agreed to pay the credit card indebtedness by periodic deductions from the cardholder's deposit account, the card issuer shall not deduct any part of the disputed amount or related finance or other charges if a billing error notice is received at any time up to 3 business days before the scheduled payment date. 3. Acceleration of debt and restriction of account prohibited. A creditor shall not accelerate any part of the consumer's indebtedness or restrict or close the consumer's account solely because the consumer has exercised in good faith rights provided by this section. A creditor may be subject to forfeiture penalty under 15 U.S.C. 1666E for the failure to comply with the requirements of this section. 15 U.S. Code 1666. Correction of billing errors. This is E. Effect of non-compliance with requirements by creditor. Any creditor who fails to comply with the requirements of this section or section 1666A of this title forfeits any right to collect from the obliger the amount indicated by the obliger under paragraph 2 of the subsection and subsection A of this section. In subsection A of this section, and any finance charges thereon, except that the amount required be forfeited under this subsection may not exceed $50. 15 U.S. Code 1666D. Treatment of credit balances. Whenever a credit balance in excess of $1 is created in connection with a consumer credit transaction through 1. Transmittal of funds through a creditor in excess of the total balance due on an account. 2. Rebates of unearned finance charges or insurance premiums. Or 3. Amounts otherwise owed to be held for the benefit of an obliger. The creditor shall A. Credit the amount of the credit balance to the consumer's account. B. Refund any part of the amount of the remaining credit balance upon request of the consumer. And C. Make good faith effort to refund the consumer by cash, check, money order any part of the amount credit balance remaining in the account for more than 6 months, except that no further action is required in any case in which a consumer's current location is not known by the creditor and cannot be traced to the consumer's last known address or telephone number. 15 USC U.S. Code 44 definitions. Documentary evidence includes all documents, papers, correspondence, books of account, and financial and corporate records. 15 U.S. Code 1693M. Civil liability. 1. Any actual damage sustained by such consumer as a result of such failure. 2. A. In the case of an individual action, not less than $100 nor greater than $1,000. 15 U.S. Code 1693N. Criminal liability. A. Violations respecting giving of false or inaccurate information, failure to provide information, and failure to comply with the provisions of this subchapter. Whoever knowingly and willfully 1. Gives false or inaccurate information or fails to provide information which he is required to disclose by this subchapter or any regulation issued thereunder, or 2. Otherwise fails to comply with any provision of this subchapter, shall be fined not more than $5,000 or imprisoned not more than 1 year, or both. 18 USC U.S. Code 1691 definitions. A. Or 1. Racketeering activity means A. Any act or threat involving murder, kidnapping, gambling, arson, robbery, bribery, extortion, dealing in obscene matter, or dealing in a controlled substance or illicit chemical as defined in Section 102 of the Controlled Substances Act. Code 3-603, Tender of Payment, UCC. A. If tender of payment of obligation to pay an instrument is made to a person entitled to enforce the instrument, the effect of the tender is governed by the principles of law applicable to the tender of payment under a simple contract. 16 CFR 681.1 B1. Account means a continuing relationship established by a person with a financial institution or creditor to obtain a product or service for personal, family, household, or business purposes. Account includes 1. Extension of credit, such as the purchase of property or services involving a deferred payment, and 2. A deposit account. 1002.2 is part of 12 CFR Part 1002 Regulation B. Regulation B protects applicants from discrimination in any aspect of a credit transaction. A. Account means an extension of credit. When employed in relation to an account, the word refers only to open-ended credit. C. Adverse actions. 2. The term does not include 3. A refusal or failure to authorize an account transaction at a point of sale or loan, except when a refusal is a termination or an unfavorable change in the terms of the account does not affect substantially all of a class of the creditor's account, or when the refusal is a denial of an application for an increase in the amount of credit available under the account. 15 U.S. Code 1692C. Communication in connection with the debt collection. A. Communication with a consumer generally without the prior consent of the consumer given directly to the debt collector or the express permission of a court of competent jurisdiction. A debt collector may not communicate with a consumer in connection with the collection of any debt. 1. At any unusual time or place known which should be known to be inconvenient to the consumer. In the absence of knowledge of circumstances to the contrary, a debt collector shall assume the convenient for communicating with a consumer is after 8 o'clock ante-meridian and before 9 o'clock post-meridian local time at the consumer's location. 2. If the debtor knows the consumer is represented by an attorney with respect to such a debt and has knowledge of or can readily ascertain such attorney's name and address, unless the attorney fails to respond within a reasonable period of time to a communication from the debt collector, or unless the attorney consents to direct communication with the consumer, or 3. At the consumer's place of employment, if the debt collector knows or has reason to know that the consumer's employer prohibits the consumer from receiving such communication. B. Communication with third parties. Except as provided in section 1692B of this title, without prior consent of the consumer given directly to the debt collector or the express permission of a court of competent jurisdiction, or as reasonably necessary to effectuate a post-judgment judicial remedy, a debt collector may not communicate in connection with the collection of any debt with any person other than the consumer, his attorney, a consumer reporting agency, if otherwise permitted by law, the creditor, the attorney of the debt collector. C. Ceasing communication. If a consumer notifies a debt collector in writing that the consumer refuses to pay debt, or that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall not communicate with the consumer with respect to debt except 1. To advise the consumer that the debt collector's further efforts are being terminated. 2. To notify the consumer that the debt collector or creditor may invoke specified remedies which are ordinarily invoked by such debt collector or creditor. Or 3. Where applicable, notify the consumer that the debt collector or creditor intends to invoke a specified remedy. If such notice from the consumer is made by mail, notification shall be complete upon receipt. D. Consumer defined. For the purpose of this section, consumer includes the consumer's spouse, parent, if the consumer is a minor, guardian, executor, or administrator. All right. 12 CFR 1002.10, furnishing of credit information. 1002.10. Designation of accounts. A creditor furnishes credit information shall designate 1. Any new account to reflect the participation of both spouses if the applicant's spouse is permitted to use the contractually liable on the account. And 2. Any existing account to reflect such participation within 90 days after receiving a written request to do so from one of the spouses. 15 U.S. Code 1681N. In general, any person who willfully fails to comply with any requirement imposed under this subchapter with respect to any consumer is liable to that consumer in an amount equal to the sum of blank. 1. Any actual damages sustained by the consumer as a result of the failure or damage of not less than $100 and not more than $1,000. Or B. In the case of liability of a natural person obtaining a consumer report under false pretenses, knowingly without permissible purpose, actual damages sustained by the consumer as a result of the failure or $1,000, whichever is greater. Such amount of punitive damages as the court may allow. And 3. In the case of any successful action to enforce liability under this section, the cost of the action together with reasonable attorney fees determined by the court. 18 U.S. Code 8. Obligation or other security of the United States defined. The term obligation or other security of the United States includes all bonds, certificates of indebtedness, national bank currency, Federal Reserve notes, Federal Reserve bank notes, coupons, United States notes, Treasury notes, gold certificates, silver certificates, fractional notes, certificates of deposits, bills, checks, or drafts for money drawn by or upon authorized officers of the United States, stamps, and other representatives of value of whatever denomination issued under any act of Congress, and canceled United States stamps. 3-603 Tender of payment. If a tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge to the extent of the amount of tender of the obligation of the endorser or an accommodation party having a right to recourse with respect to the obligation which the tender relates. 15 U.S.C. 44. Documentary evidence includes all documents, papers, correspondence, books of account, and financial and corporate records. 16 CFR 43.1 definitions. 16 CFR 43.2 preservation of consumers' claims and defenses, unfair or deceptive acts or practices. 16 CFR 433.3, exemption of sellers making or receiving open-end consumer contracts before November 1st, 1977. 28 U.S. Code 3304, transfer fraudulent as to a debt to the United States. A. Debt arising before transfer. Except as provided in Section 3307, a transfer made or obligation incurred by a debtor is fraudulent to a debt to the United States which arises before the transfer is made or the obligation incurred. 28 U.S. Code 3302, insolvency. Presumption. A debtor who is generally not paying debts as they become due is presumed to be insolvent. 15 U.S.C. 1681 I.B. Procedure in case of disputed accuracy. These are reinsertion requirements the CRA has to follow when allowing an account to be reported by a furnisher of information to report, especially after the admission was accepted when they deleted it prior. And this is all of that. I'm going to leave this on the screen because I am not going to read all of this. It's one more page, so I'll let y'all see all of this because there's a lot of stuff on here and a lot of things that they cannot do, and I'm not going to read all of it. So I hope you all have an understanding of the billing error laws that we are using to dispute the different issues that might be coming up. And of course, if you have any more questions, you can go to 644online.com. We have a something there that will provide information on how you can dispute charges that have been made against you, the real living person, versus your straw man, the dead person. So hopefully